Joining our third Holland and Hart legal update for the healthcare industry. I'm Brad Cave. I'm a partner in the Cheyenne, Wyoming office of Holland and Hart in the Labor and Employment and Healthcare groups. I'm joined today by two of my colleagues. Tim Crisp is a partner in Santa Fe. He's a finance and banking attorney, and Jay DeVoy, who's one of our colleagues in the Nevada office and the healthcare group as well. Everything keeps changing, as I know you're all aware. The regulatory guidance, the forms, the press releases just keep coming out from our federal agencies and state agencies almost on an hourly basis these days. I think this is the new normal for a while. I think we'll continue to see a lot of changing rules and a lot of changing guidance from the regulatory agencies. We're going to do our best to keep you up to date on those things through these webinars and through working with you in our attorney-client relationships. Today, Jay is going to talk with us about three different topics in the healthcare, pure healthcare law sector. He's going to touch on state orders and state immunity issues that some of the states are instituting now to kind of broaden the access to care. He's going to talk about the Stark Law blanket waiver that was recently issued, and he's going to talk about some OSHA guidance relating to respirators and masks. After Jay finishes his work, I'll turn it over to Tim, who's going to review some of the CARES Act funding issues under the Paycheck Protection Plan and the other parts of the CARES Act where there might be some financial resources available for your hospitals and entities. And I will finish up then with the new final rule on the Families First leave and some of the Q&A that came out very recently under that act as well. So with that, turn it over to Jay.
Thanks, Brad. Just going to try to start with the easier stuff first and leave the technical analysis for the end. The first thing I want to talk about are the state orders that have been coming out on kind of an ad hoc basis from different states that provide different levels of immunity for practitioners within a specific state. Two of the largest states that have been affected by the COVID-19 outbreak that have issued these orders are New York and Illinois. Illinois just came up very recently on April 3rd. New York's came out a little bit before then. They both provide very broad protection to healthcare practitioners, not just physicians, but nurse practitioners, physician assistants, registered nurses, licensed practical nurses, and a very large piece of the healthcare delivery apparatus for any care that they provide in connection with the treatment of COVID-19 for diagnosis or for treatment itself. And the importance of those states is because the protection is so broad, it has to do with basically anything that happens during the continuum of care as long as it's related to COVID-19. The policy reason for this is because there are going to be, by the nature of the disease, a lot of bad outcomes that the physicians can't do anything about. And the physicians are significantly imperiling themselves to get involved in the treatment, especially when many of them are providing services above and beyond the call of duty. And we'll get into the compensation portion of that in a moment with Stark Law. And the issue is that if you're going to have physicians putting themselves in harm's way where so many people are going to be affected with a very high viral load that initial research indicates is going to be correlated with potentially bad outcomes with the COVID-19, that they want to ensure that these providers aren't going to be gifted with a lawsuit as a reward for their considerable service to the state and their residents. So certain states, again, like New York and Illinois, have been very broad with their waivers. Other states like Nevada have not been so broad. Late last week, Governor Sisolak issued Executive Order 11 at this point, and that had to do with the immunities that were available to healthcare providers that were acting at the direction of the governor. And it's a little bit different from the other states, which have to do with all healthcare providers acting for a private hospital, for a public hospital, within their own clinics, and just providing any services in connection with COVID-19. So the important thing to check is what your specific state has done and what the limitations are, because they do vary from state to state. I have personal experience with the Nevada one, was surprised that it was not as broad as those issued by Illinois and by New York, but that's why it's important to look at these on a state-by-state basis. And if you have relationships with lawmakers, try to educate them about the various reasons why a broader waiver would be preferential to a narrow one, and look to the examples of New York and Illinois to see what's feasible in terms of broadening the scope of the waivers that are available to provide the maximum amount of protection to healthcare providers and their employers and the systems in which they work. The other piece of guidance that came out very late last week is from OSHA. It has to do with the use of N95 respirators in all workplaces, but especially for healthcare providers as well. The recommendation is that where the respirators are available, they be used and they be distributed to all employees who have contact or potential contact with COVID-19. Now, there is some enforcement guidance that was issued as part of this recommendation, and it varies a little bit for all employers versus healthcare employers specifically. For all employers, extended use or reuse of the N95 masks is permitted as long as there are policies and procedures in place and the employees are trained about making sure the seal is in place. They know how to check the seal for its efficacy, and that the integrity of the filter is maintained throughout the course of use or reuse, by which they mean there's not paint in it, it hasn't been physically damaged, it hasn't been tainted by blood or other bodily fluids, and things of that nature to make sure that the N95 filter is still working as it should. Now, there is a provision where expired N95s can be used as long as the employer can show that they have tried to obtain the current and still effective N95 masks that are within their recommended time period. And the reason why that's significant is so that employers know that they can document their efforts to obtain N95 masks, whether through purchasing directly through medical supply companies, purchasing through Home Depot to the extent that stores like that are open, from trying to purchase through other retailers that might not be an obvious source of them, such as marine supply shops and paint stores, and trying to document their efforts to obtain current and effective non-expired masks in order to show that the only thing that was available were these expired masks, whether they were purchased previously or acquired through donations. For healthcare providers, there's a special provision where the use of expired or reuse of N95 masks is not allowed where there's going to be surgical procedures performed that could expose the staff to people who potentially have COVID-19. And the reason for that is concern about aerosolization, which becomes a factor in certain forms of surgery where there might be blood spatter or other procedures that result in the aerosolization of blood or other bodily fluids in a way that wouldn't be as much of a concern with daily interaction in a clinical setting, such as for a general checkup where there's droplets, but not necessarily that aerosolization. So there are special concerns, and to the extent that the N95 masks can be conserved for those procedures, it seems like that's the most prudent course of action to stay within OSHA's regulatory guidance and the discretion that it specifically reserves. There's 4 factors that OSHA identifies as guiding its discretion as to how and when to enforce these rules and whether to do so, namely looking to whether the employer has made a good faith effort to obtain other filtering devices, if the employer has made other non-N95 masks and protection available, such as eyewear and general surgical masks that don't meet the N95 standard but still provide protection to employees, and whether the employer has acted within CDC guidelines to monitor their supply of N95 face masks. And now the CDC guidance on this is pretty comprehensive, but at the same time, no matter what the CDC says, for the rate of consumption that some of these hospitals and other facilities are having, no matter what best practices are in place, there's enough strain on the supply line that it's going to be very difficult for them to comply with those guidelines and to maintain an adequate stock of these N95 masks. And finally, there's a catch-all for other measures that have been used by the facility, such as access limitation, using partitions, and coordinating patients and moving them into other areas to sequester, for example, COVID-19 patients from the rest of the hospital or from the rest of the facility, that could be used to convince OSHA to use its discretion not to seek a further enforcement of that rule and how the N95 masks are to be used. Finally, on March 30th, 2020, the Centers for Medicare and Medicaid Services, which I'll just refer to as CMS, issued a blanket waiver for Stark Law provisions that apply to physicians and any physician organizations that they stand in the shoes of with respect to their referral relationships with entities with which they or an immediate family member have a financial relationship. That can include a ownership interest, that can include a compensation arrangement such as a contract or an employment relationship, again, not just with a physician, but an immediate family member such as a parent, a child, or a spouse, to use the most common examples. Now, although these are called blanket waivers, CMS has been very clear that this relates only to COVID-19 purposes and enumerates 6 of those purposes for which these referrals would fall within that waiver. First is the diagnosis or medically necessary treatment of COVID-19, whether or not the person is actually diagnosed with it. So if a physician seeks to obtain a diagnosis or performs a test on a person, they don't test positive for COVID-19, that doesn't knock them outside of the waiver. It's related enough to the COVID-19 pandemic that it would fall within it. Other bases for which the referral waiver would apply involve securing the services of physicians and other healthcare practitioners to treat the outbreak of COVID-19, ensuring the availability of healthcare providers and expanding the capacity of healthcare providers to address COVID-19, shifting the diagnosis and care of patients to appropriate alternative settings, such as getting COVID-19 patients out of the hospital and into other settings where they can be physically kept distant from other people who are in hospitals to prevent cross-infection, such as, for example, if people in the hospital for non-elective emergency procedures, such as from accidents or coronary events, and finally, to address medical practice or business interruption due to the COVID-19 outbreak. So there are 18 specific waivers that were covered within the blanket waivers that CMS issued, again, solely for the treatment and abatement of the COVID-19 pandemic. These were enumerated in documents that were released by CMS. The main consideration that CMS embodied in all of these waivers that I won't bore everyone too much with is largely to facilitate healthcare and do away with the requirements for fair market value and concerns about compensation being above market or specifically below market for physicians and entities working together to either provide enhanced services, to rent space for patients, or to rent equipment used for the treatment of patients. Whereas normally an entity such as a hospital and a physician would get in trouble for a lease that was either above or below market, whether for space or for equipment, that has been done away with the idea that CMS is not going to investigate whether the lease value is above market or below market, such as, for an example, a physician leasing excess office space that they have at this time due to a decrease in clinical activity to a hospital so the hospital can use that space for administrative functions or to place COVID-19 positive patients to keep them away from the rest of the hospital census, and the physician offering to do so for, say, $100 a month or $1,000 a month when the fair market value rate would be much higher. That recognizes the fact that the physician can't necessarily do it for free, but rather than going through the process of obtaining a whole valuation, the goal is to, again, facilitate treatment for people who have COVID-19 and to avoid the strain on existing medical facilities. Other things that have been loosened have to do with the compensation due to physicians. The waiver allows for additional compensation to be paid to physicians for their emergency services and the additional hazards they experience in providing treatment in connection with COVID-19. Other things that have been relaxed have to do with the non-monetary compensation and the incidental benefits that hospitals in particular can provide to healthcare providers. And this covers a wide range of things from meals to protective equipment to child care for physicians who are on staff. There are certain nuances to this. For example, loans that could be issued by an entity such as a hospital to a physician, they can have below fair market value interest rates or terms that are not available from a lender that isn't in a position to generate business for the physician, such as a bank. That one stands out because it specifically says or and not and or, and as a result it might be disjunctive, where the benefit that can be realized is either a below fair market value interest rate or other more favorable terms other than the interest rate, but it doesn't say and or. So some caution would be necessary in the course of making a loan. And there are other provisions that are specific to ambulatory surgery centers that are seeking to be or have recently been converted to hospitals and the rules that apply to them. But otherwise, the important takeaway for these relationships, which should all be examined, even in the great haste that hospitals and physicians need to enter them, is that the standards for commercial reasonableness and fair market value have been relaxed. And there are certain exceptions as well for dealing with group practices and the distinction between a member of a group practice, which is an owner or an employee of it, and a physician in a group practice, which can apply to a contractor. And the language that was used in the waivers is very specific and further defined within Stark to be as broad as possible. So these are things that, depending on the specific relationship, need to be addressed in more detail. But the general rule, again, is facilitating the relationship between hospitals or other entities and physicians for providing care, getting additional manpower, and facilitating the use of space and other resources for treatment. And at the end of the waivers that were released by CMS, there are about 2 pages full of examples with relationships between physicians and hospitals or hospitals and physicians and home health agencies, and the ability to purchase equipment to lease space, and also the relaxation of the documentation requirements, where these relationships can be formalized, whether through the sale, the lease of equipment, or the recruitment and contracting of other providers. And those relationships can go forward even without the signed document that would normally be necessary to qualify for an exception to falling within an impermissible financial relationship within the Stark Law. So there's a lot more specificity that can go into that we recommend, to echo what Brad said, obtaining an opinion through legal counsel in the course of that relationship, but to identify the key takeaways from this Stark waiver with respect to services being provided in connection with COVID-19. A lot of the standards for documentation and for fair market value and the commercial reasonableness of those agreements have been alleviated just for this period of time, and eventually this will abate with the end of the COVID-19 pandemic. And with that, I turn over my time to Mr. Crisp and Mr. Kaye.
Great. Thank you, Jay. This is Tim Crisp. I'm here today to talk about the CARES Act, or the Coronavirus Aid, Relief, and Economic Stability Act, that was passed into law just a little over a week ago. Excuse me. The CARES Act has a number of features, much of it dealing with the various things having to do with the healthcare industry and the pandemic. I'm here today just to talk about the financial assistance programs that are available to many healthcare providers as well as other businesses and nonprofits. The primary loan facility available to smaller businesses, and we'll talk about what that means in a few minutes, is called the Paycheck Protection Program. And this is a loan program that would it's basically set up by Treasury and the U.S. Small Business Administration. And it involves loans being made by banks and credit unions and other SBA lenders directly to affected business concerns and nonprofits. We'll talk about some of the eligibility things in a little bit, but basically these are SBA guaranteed loans. They have some very, very nice, attractive features such as payment deferral and loan forgiveness. And so it's been an exceptionally popular program. The SBA just started accepting applications for this, as did lenders, last Friday, and there's already been billions and billions of dollars of these loans that have already been approved or spoken for. Who is eligible for this loan? You're eligible if you are a business concern or a nonprofit that had employees or has employees and was in business as of the beginning of this year. You basically can get a loan or apply for a loan under this up to a sum of 2.5 multiplied by, in general, your average monthly payroll costs that you were incurred and paid during 2019. There are some different rules in terms of measuring that if you weren't in business for all of 2019 or if you're a seasonal employer, but for most employers, that would be your average monthly payroll costs incurred and paid during 2019, multiplied by 2.5, and that's the maximum loan amount that you can take out. If you are approved for the loan, you can use the proceeds of the loan during the next 8-week period for eligible payroll costs, as well as, if you have them, mortgage interest but not principal, rent on obligations that were incurred on or before February 15th, and utilities where service was set up on or before February 15th. The payroll costs that are included include salary, wages, commissions or similar compensation, payments for vacation, parental, family, medical, or sick leave, severance payments and other allowances for dismissal or separation, group health care benefits payments, including group health insurance premiums, any retirement benefits, as well as state or local payroll taxes that are assessed on the compensation of the employees. Couple notable exceptions to that: you can't include in those payroll costs any compensation of a non-U.S. resident employee, and you also can't you cannot include the compensation of an individual employee that exceeds $100,000 on an annual basis of their salary. So, and that would be an annualized basis. So, for example, if you were paying an employee $10,000 a month, you are only able to count about $8,000 and change toward your eligible payroll costs that you can use to fund the loan, to use loan proceeds for. So who is eligible for this loan? Well, as I say, if you're a business concern or a nonprofit organization, and there are also a couple things for veterans organizations and tribal business concerns. But if you are a small business, meaning that you have, in general, 500 or fewer employees when counted with your affiliates, and I'm not talking about full-time equivalent, I'm talking about a part-time employee is counted the same as a full-time employee here. If you have 500 or fewer, then you are considered a small business and can apply for the program. If you have more than 500, or if there's a higher threshold set forth in some existing SBA regulations for your particular industry, then you are not eligible to apply for this program, but you may be eligible to apply for a loan program for mid-sized or large businesses that is being set up by the Treasury Department, probably to be unveiled in the next few weeks. Now, the 500 employee limit is one that has been on the books for a while with the Small Business Administration, and it's brought into this payroll protection or paycheck protection program as well. And the SBA counts that not just by counting your employees, but also those of entities that are affiliated with your business. So, and that's not for purposes of determining your loan amount or what you can use loan proceeds on. They only count your employees for that. But for purposes of whether you are a small business and thus eligible to participate in the program, they use what are called affiliation rules. And they will deem any business entity that is affiliated with you through you controlling them, them controlling you, or you and them being under common control of somebody as being affiliates of you. So, for example, if you have a subsidiary that has employees and you own a majority of the voting interest in that subsidiary, those employees of that subsidiary would get added on to your employees for purposes of determining whether you're eligible to participate in the program. The same thing is true for entities that hold a majority of the voting equity in your operation or that control you. If you are a nonprofit organization, you can have control through other means, such as support or outsized influence. So there's control by a majority of voting equity. There's also control by a less than majority of the voting equity if an entity holds a disproportionate amount of the voting equity compared with the voting equity held by others. So, for example, if an entity held 40% of your voting stock, but the other shareholders only had 5% or less, you would have an outsized influence, and the SBA would likely deem that entity to be an affiliate of yours. There is also affiliation through common management. So, for example, if a majority of the board of directors or board of managers, or if the top positions of typically chief executive or president are the same between entities, even if there is no common ownership or other affiliation, the SBA can deem them you affiliates of each other. Also, if there are individuals who are ultimately hold the direct or beneficial stock or equity interest, and those individuals control other entities, or their spouse, their parent, children, or in-laws control them, they can take those entities owned or controlled directly or indirectly by them and add them to your employee head count to determine whether you are 500 or fewer employees and thus eligible to participate in the program. Lastly, if there is an entity, whether or not it holds any significant ownership interest, but that has extraordinary contractual voting rights, such as the ability to or the ability to prevent you from changing your budget or adopting your budget or making certain corporate changes or things of that nature, the SBA has deemed that control, and so that can cause an affiliate situation as well. So those are and again, with affiliation, less is more. So you want fewer employees, you want fewer affiliates if at all possible. But this is important because when you are applying for a Paycheck Protection Program loan, you will have to make a certification to the bank as well as to the SBA that you do meet these standards, including through the affiliation rules, and that you qualify to apply for and receive the loan. Making a false statement on that can be a federal crime of bank fraud and fraud on a government agency, neither of which your institution or certifying officer want to be involved in for sure. So assuming that you get, I should mention too, because one question that's come up in healthcare fairly frequently in the past couple of weeks since this program is announced is, if you are a municipal body, let's say a public hospital owned by the county or a municipality, are you eligible to participate in this program? And the answer is, unless you are a 501c3, you probably are not, because you probably do not meet the SBA's standard and definition for what constitutes a business concern. Does that mean that public hospitals and healthcare facilities are out of luck? It does not. They may be entitled to relief under the second phase of the program for mid-sized and larger businesses, even if you're a small business, because that program is also set up to enable states and municipalities, including public hospitals and other public institutions, to be able to apply and participate. So if you reach the point where you conclude that you're eligible to apply for this program and you figured out what your average monthly payroll costs were in 2019, you multiply that by 2.5 and you get a loan amount, and you go to your friendly neighborhood bank or credit union or other SBA lender and fill out the paperwork, hope for the best, and you hope you get your application in very quickly, because the $349 billion in funds that have been appropriated for this are going exceptionally quickly, and they will be depleted very soon. So if you are planning to apply, I recommend that you reach out to your bank or credit union right away. If they are not an SBA lender, I recommend that you get referrals and get their assistance in helping you work with a institution that is. So if the loan is made, you get the money. Congratulations. That's the purpose of this money is basically mostly to pay your payroll costs for the next week. So Uncle Sam is basically stepping in. They realize there's economic hardship here. You don't have to prove that you have suffered a loss directly. Congress has concluded that pretty much any business in the country has. And so assuming you're eligible and you get the loan, you then get to spend most of those loan proceeds, a minimum of 75% of them, during the next 8-week period, which is your test period, on your payroll costs. All those items we talked about earlier, in addition to salary up to $100,000 annualized per employee. You can use up to 25% of the loan proceeds on your rent costs, your mortgage interest, and your utilities costs, but not more than 25% in the aggregate for all of those things. After that 8-week period, you will be able to apply for forgiveness of the loan. And basically what that is going to look like, although we have not seen the applications or specific rules dealing with this, but you will be applying to the bank and to the SBA and providing payroll documentation and cost documentation showing that hopefully you spent all of those loan proceeds on those permitted purposes, including not less than 75% of them on eligible payroll costs. If you do that, and if you're able to show that you had spent it all on those permitted things, you have a very good chance of getting all or a good portion of your loan forgiven by the SBA. And basically what happens is the SBA buys that portion of the loan from the bank and it's forgiven. I should mention too that with debt forgiveness under this program, unlike customary debt forgiveness, you will not be taxed. There is no 1099 that goes out to the IRS, like in most cancellation of debt situations, like where you write off a patient debt. In this case, the CARES Act makes clear that this is money that is forgiven and you're not taxed on the benefit of that. If you are unable to use all of that loan proceeds on those permitted purposes within that 8 weeks after disbursement, the remaining portion is not forgiven. And so that becomes a loan that is payable within 2 years from disbursement. You have up to 2 years to pay it. And the first 6 months, you do not have to make any payments on it. For the remaining 18-month period, you'll have to make principal and interest payments, generally sufficient to be able to amortize it over that remaining period. So back to loan forgiveness. We talked about how you've got to spend all those funds, hopefully within the first 8 weeks. However, the amount of loan forgiveness can be reduced to the extent that you have payroll reductions that have not, or you make additional payroll reductions, or you don't bring yourself up to prior year payroll levels, or you don't bring yourself up to prior year headcount levels, or to the extent that you have reduced or do reduce any employee's salary by more than 25%. All of those things can result in a reduction of the amount of the loan that's forgiven, even if you do spend all of those funds on permitted payroll costs. So this is a real incentive from the government to bring back laid off or furloughed workers, to fill unfilled positions, to try to get people on the payroll. They don't care whether, the government doesn't care whether they're doing anything productive or have the same job as they did before. The real gist of this is they want to get people out of the unemployment rolls, and they want to get money into their pocket to try to help the economy in these troubled times. So that's kind of how the loan forgiveness works. Let's say you do have a balance that is unforgiven. That is not a problem. The government is not going to go after you, or the bank isn't going to go after you unless you default on that, which hopefully you won't. Again, you have to pay it off by the end of year 2, and you have a 6-month payment deferral. There are no personal guarantees or collateral required under this loan, so it's very attractive. And the loan bears interest at 1% per annum, no fees or anything like that. So it is a very attractive program, even if you do end up with a loan balance that you have to pay off. I will recommend strongly that you check your existing indentures and credit agreements that you might have to make sure that you are not prohibited from incurring the kind of debt or contingent debt that's in this program if you do apply. In general, I've been finding that lenders think this is a great program, and it's basically like equity coming into the provider. And so they're more than eager to grant a waiver or carve out from existing covenants that might prohibit that. And with that, like I say, there is also a program for entities that are larger than the 500 limit or other applicable limit, or that are public hospitals. That loan program is going to be set up through Treasury, and we should be seeing some rulemaking and probably the first loans being made over the next month or so. And with that, I will turn it back to Brad.
Thanks, Tim, and thanks, Jay. I will pick up with the latest changes to the Paid Sick Leave Act and the Expanded FMLA Leave Act that have come out in the last few days. So Thursday evening, the Department of Labor issued 20 new questions and answers under their ever-growing Q&A document that's available through the DOL website. And then they also published on Friday proposed temporary rules for the Family First Coronavirus Response Act. Those proposed temporary rules became final today and were published in the Federal Register as final rules this morning. So we've got a couple of different new resources to help us deal with the details of complying with the Paid Sick Leave Act and the Expanded Family and Medical Leave Act. I start with what's important to this group. The definitions of healthcare provider and of emergency responder came through from the Q&A of a week ago to the final rule published today. They came through intact. So all of your work to decide whether to exempt employees, if you're a healthcare provider, whether to exempt all your employees or some of your employees, that work is all still preserved and protected under the definitions that were finalized this morning. There are still some questions about how that right can be exercised by healthcare employers, including whether it's an all or nothing exclusion, whether you can exclude certain groups of employees, et cetera. It's still our opinion, the people in our group here at Holland and Hart still believe that the language of the statute and the regulation supports exclusion on the terms that the employer decides to exclude. I think you have to be careful to not exclude people based on likelihood of using Family and Medical Leave Act, Expanded Family and Medical Leave Act, or Paid Sick Leave Act. So I wouldn't exclude all of your single moms. That would lead to a discrimination claim. But in general, I think you have the flexibility to make those exclusion decisions in a way that fits your organization, as long as it's done in a legitimate, non-discriminatory way. So that's good news for those of you who have been struggling with the exemption parts of this. I'm going to roll through these topics based on the order that they show up in the new Q&As. This is going to be a little bit haphazard. DOL has not organized the Q&As or reorganized the Q&As based on topic. Ultimately, that's good for us because we'd have to go back and figure out what's new that's being inserted in different places. So it's helpful when you're looking at the Q&As. It's probably not as helpful for a presentation like this, but I think it makes sense just to march through them in the order that they're provided. And then I'll add a few things from the regulations that I think are interesting. The first Q&A that's helpful or that provides with good guidance is some definition of federal, state, or local quarantine or isolation orders. That was not defined in the Q&A. It was not defined in the earlier versions of the Q&A. The regulations and the Q&A now make it clear that quarantine or isolation orders include the shelter-in-place or stay-at-home orders that cause an employee to be unable to work. Several of our states have those orders in place now. My state of Wyoming is one of only 7 states in the nation that does not currently have a stay-at-home order, but I know our governor is under a lot of pressure to institute one. An important part of the Q&A and the regulations make it clear that the order has to be the reason that the employee is unable to work. If the employer does not have work for the employee to do, the employee is unable to work because of the employer's lack of business or lack of work, not because of the shelter-in-place order. So the shelter-in-place order has to be the cause of the employee's inability to work or telework, not simply the second reason that the employee is unable to work or telework. The Q&A also went on to say, or the supplementary material as part of the regulations, went on to say that the term federal, state, or local quarantine or isolation order is intended to cover a broad range of government orders. I think that if your state or local governments issue an order saying, no essential travel or no non-essential travel, and they do not exclude from that travel to and from work, that's the kind of order that I think would also fall within this. So there's a variety of orders that might now come within the scope of a quarantine or isolation order, which could cause employees to be entitled to use paid sick leave under the Paid Sick Leave Act. We have received a lot of questions about vulnerability, health vulnerability, when employees who have no symptoms of COVID-19 but have been to their doctor and they work for a healthcare employer, and their doctor, because of some underlying immunodeficiency disorder or something like that, their doctor has recommended that they not come to work in the healthcare setting. The Q&A and now the regulations have confirmed that on doctor's orders or on provider's orders, a person with a healthcare vulnerability can take paid sick leave under the Paid Sick Leave Act, even though there's no diagnosis and they are not suffering from COVID-19. So that's a good clarification, giving some guidance to answer a question that many of us have had over the last week and a half or so. Self-quarantine. You may have had employees who have told you that they either have some COVID-19-like symptoms or they don't have any symptoms, but they're scared of getting COVID-19 and they've decided to self-quarantine, but they are not seeking a diagnosis and they haven't been to the doctor. That person is not eligible to take Paid Sick Leave Act pay. They have to be taking affirmative steps to obtain a diagnosis, and that would include making an appointment, waiting for an appointment, or going to an appointment to get a diagnosis before they're eligible for Paid Sick Leave Act pay. So this generalized fear of getting coronavirus does not entitle a person to anything unless they're affirmatively pursuing a diagnosis and they have to have symptoms of COVID-19 in order to fall within that Paid Sick Leave Act qualifying reason. So self-quarantining for the sake of self-quarantine is no longer an available option for employees. Under the Paid Sick Leave Act, one of the qualifying reasons for leave is caring for an individual who is subject to a quarantine or isolation order or who is self-quarantining under the healthcare provider's advice. The Act didn't define who that individual was. It didn't establish any sort of relationship requirement to the employee. It just said caring for an individual, which obviously left a lot of ambiguity and a lot of room for abuse in that particular lack of a definition. The Q&A and now the regulations both tell us a few things about that person. That person has to be unable to care for himself or herself. They must genuinely need the employee's care, and providing that care has to prevent the employee from working or teleworking. The employee or the person needing the care can be an immediate family member, someone who regularly resides in the employee's home, or someone whose relationship with the employee creates an expectation that the employee would care for that person and the person depends on the employee for care. So this narrows the scope of the undefined individual who the employee can take leave to care for. It narrows it right down to a person, within that relationship, lives in the home, immediate family member. They need the care, and the employee would be expected to provide that care. So that's helpful delineations for us to use in that particular qualifying reason. A little bit of clarification on who constitutes a child. Child now includes everybody through the age of 18. There was some confusion about that due to an earlier or due to the language in the Act. Under part of the language in the Act said up to 18. The regulations, the Secretary now said, well, we're going to make it 18 because the other part of the Act uses through 18 or under instead of up to 18. So now the general definition of child is 18 or under, and the regulations make clear that the child can be over the age of 18 if the child has a disability and cannot care for himself or herself and their school or place of care is closed due to COVID-19 related reasons. The child care, there's some new child care definitions that are helpful to some extent, but also create some confusion, at least in my mind. First of all, the place of care has been defined as a physical location where care is provided for the employee's child and can include daycare facilities, preschools, before and after school programs, summer camps or enrichment programs, respite care programs, schools, or homes. So the place of care is the place that's been closed because of COVID-19 concerns. A child care provider, and this is for deciding whether your child care provider is unavailable, a child care provider is someone who cares for an employee's child on a regular basis and is compensated for that care, and they're licensed or approved. The regulations throw in this apparent requirement for licensure or state certification that was not present in the Q&A 3 days or a day earlier. It can also include, child care provider can also include those like relatives or neighbors or friends who care for the child on a regular basis. They're not licensed and they may or may not be compensated. So it seems like we have a gap now in the regulatory definition of child care provider for those situations where the provider is employed for compensation on a regular basis directly by the employee, like an au pair or a nanny, for instance. So a little bit, I think the regulations have thrown in a little bit of ambiguity now that the Q&As did not have. We'll see how that shakes out as we go forward. But if you're questioning whether an employee's child care provider is no longer available, or whether the person that they're referring to as being no longer available was in fact a child care provider, we'll need to march through the regulatory definitions pretty carefully there. question I had received from clients that is now addressed through the Q&A and the regulations are what happens when there's lots of people available to take care of the kid at the employee's home. When the child is school is closed and they're at home, and you know that there's a spouse, you know that there's an older sibling over the age of 18 that's available, you know there's a grandparent living in the home. All of those have raised questions about, well, why does my employee need to take 12 weeks of leave under the Expanded Family and Medical Leave Act to take care of that child? And that is a perfectly legitimate question, and the Q&A and the regulations now allow employers to question that situation and require employers to obtain a statement from the employee that there is no other suitable person available to provide care for the child. And you can use that requirement to ask some very direct questions of employees when you have reason to believe that there is, in fact, other suitable child care available at the home. The Q&As recognize that school is closed even when the school is attempting to instruct students through online resources or through homework that's been instituted and is delivered to the student to do while they're at home. The school may be trying to operate online or operate through these other means of providing schoolwork to students, but the school is not open until the physical location is open, and there was some confusion about that. Other people's kids is a question that the Q&A addresses. When can the employee take leave to take care of somebody else's children or somebody else's kids? The Q&A make it clear that the leave is generally available only for biological, adopted, legal wards, or foster children of the employee, and any child for whom the employee stands in loco parentis, meaning that the employee has day-to-day responsibilities to care for or financially support the child. So if the employee is taking time off to care for some different child that doesn't fit within those parameters, they have to fit within that parameter for caring for another individual. And that only applies in the situation where that other individual is under an isolation order, a quarantine order, or is self-quarantining. So if there's another child outside of those categories I already stated, that has to be a child who's living in the household or who's maybe living outside the household, but the relationship is such that the child has a reasonable expectation that the employee is going to care for them and the child genuinely needs the employee's care. So the guidance to take away from that is don't say no immediately to the idea that an employee may be entitled to leave to take care of somebody else's kid. You have to ask some more questions about whether that person, that other child meets the definition of an individual, which I talked about before. One of the reasons for sick leave under the Paid Sick Leave Act is that the employee is experiencing a substantially similar condition to COVID-19 specified by the Secretary of Health and Human Services. The Q&A very helpfully told us that the Secretary hasn't identified any such conditions yet. So there's no other, that's category number 6 under the Paid Sick Leave Act. There's no other conditions that qualify for that kind of leave right now. So that helps clarify that if you're sick with something else other than COVID-19, you're not falling within the Paid Sick Leave Act. You might fall within traditional Family and Medical Leave Act if it's a serious health condition. So don't forget that that's still back there for covered employers under the Family and Medical Leave Act. The Q&A gave us some good guidance on calculating the number of hours of leave that a part-time or variable schedule employee is entitled to, and how to calculate their pay. I won't go into those in detail because you'll need to sit down with the formula and actually prepare the spreadsheet or figure it out by employee, but it's helpful in how you figure out over time. It's a look back to figure out the number of hours the person is entitled to have. You figure out a daily average over the last 6 months that the person has worked. You multiply that by 14, and so that gives you the amount of hours of leave that a variable schedule employee would be entitled to. For instance, for your PRN people, that analysis would apply to a PRN person who doesn't work a regular schedule. The Q&A talks about those who are out on workers' comp and temporary disability. If an employee is receiving workers' comp benefits, including temporary total disability benefits, they are not eligible to take paid sick leave or expanded family and medical leave while receiving those benefits. If they have been released to return to work on light duty and they're able to return to work on light duty, then they might be qualified to use those leave entitlements, provided the employer would have work for them to do on light duty. Similarly, if an employee is on a leave of absence, if they're on a mandatory leave of absence imposed by the employer, they cannot take expanded Family and Medical Leave Act or paid sick leave for any qualifying reason, because they're not working because of the mandatory leave or the mandatory furlough. If they're on a voluntary leave, in other words, if they've taken leave at their own request, it's not been mandated, they can terminate their voluntary leave, present themselves to return to work, and if they have a qualifying reason at that point, then they can then take their entitled Paid Sick Leave Act leave or expanded FMLA leave. The Department of Labor has told us that they will not bring enforcement actions for violations of the Act occurring through April 17th of 2020, provided the employer made reasonable good faith efforts to comply with the Act. But if the employer, if the violations are willful, or when the DOL raises concerns, the employer refuses to commit in writing to comply in the future, or refuses to fix a past violation, the DOL reserves the right in those cases to bring an enforcement action. So those are, the DOL is giving us breathing room in one sense, but also telling us at the same time that you should not take advantage of that breathing room, nor should you ignore the requirements of the law on these compliance things. The regulations addressed the issue of intermittent leave. This had been touched on in prior Q&As, but the regulations confirmed that the employer and the employee can agree that these kinds of, or that leave under the Paid Sick Leave Act or the Expanded Family and Medical Leave Act can be taken intermittently. When the employee is able to telework, the employer and the employee can agree about the schedule of the telework and how the hours are going to be reported, and they can keep track of what amount of leave is used intermittently when teleworking is available and when it's not. So there's good flexibility there for teleworking. The regulations also made it clear that using intermittent leave when you're returning to the work site is only available when you're taking care of a child that's home because their school is closed. If you're taking care of someone that's under an isolation or quarantine order, or that's self-quarantining, or that has symptoms, et cetera, you're not permitted to use intermittent leave under the Leave Acts to return to your site of your actual office or your work site. The rationale for that is there's no reason to encourage people to come back to work or to leave home when they might either bring the virus with them from home, or they might bring the virus back from work to a vulnerable person at home. So the intermittent leave when you're returning to the work site intermittently is only available when you're taking care of the kid because the kid's home from school. Employee notice has been an area of some questions. The regulations make it clear that the employee has no obligations to give oral notice of the need for leave until the second day. So the first day, the employee may not be present the first day, may call the second day and say, hey, I need leave under the Paid Sick Leave Act or the Family and Medical Leave Act, and that's all that's required of the employees by day 2 to provide you with notice of the need for the leave. Then, after that time, the employer's requirements for the usual and customary notice and procedural requirements for requesting leave can kick in. So it gives the employees kind of a day there where you have to be careful not to impose a notice requirement for that first day. The regulations give us some detailed documentation requirements, and they put the onus on the employee to provide the employer with this documentation that's listed, and it includes most of the things that you would expect. All of the various details of the different kinds of qualifying reasons have to be provided by the employee to the employer in some form of documentation. And it's important for the employer to get that documentation so that the employer can prove their right to the tax credits for the leave as they take those tax credits and prepare the documentation to support that. The regulations over and over again, and I'll close with this, the regulations over and over again reinforce the fact that this paid leave, either under the Paid Sick Leave Act or the Expanded Family and Medical Leave Act, are not available when an employer has laid off the employee or furloughed the employee because of lack of work. In that case, the reason the employee is off work is not one of the qualifying reasons under the Act. So that's where we'll wrap it up today. I realize, again, we're moving very quickly in these areas. We appreciate your attention. We appreciate the opportunity to help you in any of these areas. Please feel free to contact Tim or Jay or I, and we'll be happy to try to answer your questions in your particular setting. Thank you. I hope you all stay healthy and have a great day. We're signing off.